Good afternoon, good evening, I should say. My name is Jordan Walker. I am an attorney with the law firm of Seaver Walker Paget. Thanks for joining us this evening to talk about eminent domain, to talk about the Heartland Pipeline project and what to do when a pipeline needs your property, uh, for this type of project. And with that being said, we're going to go ahead and get started. Yeah, and my name's Jordan Walker. I'm with Seaver Walker Paget. That is our address in Springfield. That is my phone. That's our Illinois phone number. That is my direct number, and that's my email address. If you guys have questions after the presentation, if you have questions during the presentation, feel free to jot them down. We will address them at the end of the presentation using the chat function in Zoom. Hopefully I answer most of your questions during the presentation, but if I don't, we will definitely open it up to any questions you might have. Uh, just as an introductory slide, we like to kind of tell people who we are before we get into the meat and bones. Seaver Walker Paget is a eminent domain only law firm. So our firm, my firm, the firm that I'm a part of, we only do eminent domain. And not only do we only do eminent domain, we only work for landowners. We have never worked for the pipeline, a pipeline. We've never worked for IDOT, Illinois Tollway, yeah, you name it. Any entity that can acquire land, we've never worked for them. We are strictly landowner only. And I do want to stress that we do not work for A&R. We are not TC Energy. And it seems obvious, or it may seem obvious, but a lot of folks are kind of sometimes confused about our mailer and who we're representing and if we're on behalf of the pipeline or who we are and what we're doing here. We are not with them. We are on our own helping out landowners such as yourself that are faced with this pipeline project. Because we are eminent domain only, because we are landowner only, we have accrued quite a bit of experience in this area. We've handled hundreds of pipeline cases, thousands of eminent domain cases, tons of utility projects, not only in Illinois, but across the country in Iowa, Indiana, Ohio, Kentucky, Missouri, Texas, Georgia, Tennessee, you name it. We have done utility work there, eminent domain work for landowners. So because we've done so much, we've accrued so much experience. We've seen every possible scenario seemingly that's come across that could happen. And so what we're doing today is to relay that experience, relay that education that we have seen, share with you our knowledge, share with you our experience. So when and if A&R TC comes in, starts making offers to you, trying to acquire your land, you'll be better equipped. You'll be well equipped to know how to handle it, know what to do, what to say, what not to say, and what the implications are of any action you might take. Today, we are going to be talking about the project. We're going to be talking about eminent domain. And like I said, most importantly, we're going to be sharing our knowledge, what to do when negotiating with pipeline companies. So briefly on the project, the Heartland Pipeline project. So it's in Illinois, Wisconsin. It is largely in Illinois. A good chunk of it is in Illinois, but there is some small segments up in Wisconsin as well. What you're looking at is various loops. Loops is a pipeline term that basically means running a parallel line right next to an existing line. So depending on where you're located on this project, you could be getting a new 36-inch pipe, you could be getting a new 42-inch pipe, you could be getting a 12-inch pipe, or you could get a pipe being replaced in large from 18 to 30 inches. So it's an interesting project. It's obviously in various locations. It's just not one pipeline in one area. So depending on where your property is located, that'll affect what they want from you, what they need from you. I think the most important takeaway from this is that this is a FERC pipeline. And what that means is that it is governed by the Federal Energy Regulatory Commission, the feds, known as FERC. The FERC approves natural gas pipelines, especially interstate natural gas pipelines. So they're under FERC jurisdiction. And so what that means is that in order for A&R to build this thing. They can't just start building. They need to get approval from the feds before they begin construction of the project. They did their pre-filing application, which is, as you might imagine, the precursor to the actual filing at FERC, seeking a certificate to build this. They did a pre-filing about a year ago, and I believe they filed their actual certificate last year, and they are expecting approval from FERC about a year from now, early 2026. And why this is important is that because this is a FERC pipeline, because the pipeline needs to go to FERC to get approval, that is where they will find their eminent domain authority. And we'll get into what exactly eminent domain is here in a bit. But it's important to remember that with that FERC certificate, which we are presuming they are going to get, I'm not here to say they definitely will, or that it's a foregone conclusion, or that if you are maybe fighting this project, or you're not a fan of it, and you are electing to vocalize your concerns at FERC, I understand that. We're not here to discourage people from doing that. What we are here to do is to say that we are assuming, for purposes of this presentation, that they will get FERC approval. I will say that FERC generally approves pipelines that are presented to it. I don't know the percentage specifically, but it is a pretty high percentage. Very rarely do pipeline projects do not get approved from FERC. Most of them do. If they don't end up being approved or built, it's usually because the pipeline decided not to build it. So again, for purposes of this presentation, we will assume they will get this FERC authority, this FERC approval, and with that FERC approval comes the ability to exercise eminent domain. What is eminent domain? Eminent domain is the power to seize private land and put it to a public use. Now, you might be asking yourself, this is a pipeline owned by a private company. How does that work? Well, courts have determined that pipelines meet the determination of public use. So even though A&R, TC Energies are private companies, publicly traded, but private companies, privately held companies, they have the ability to utilize eminent domain, much like IDOT would, or Kane County, or any governmental entity in the state of Illinois who has this inherent ability to exercise eminent domain. They are delegated this power. A&R receives the eminent domain power through the FERC certificate that I mentioned, meaning, again, assuming they get the certificate, that they can take your land through the eminent domain process, ultimately whether you like it or not. On the same coin, though, just because they can take it and just because they can exercise this power to take your property, it doesn't mean that you're entitled to nothing or you're entitled to whatever they say you're entitled to. You are entitled to just compensation for your property. And this is codified in the Bill of Rights and the Fifth Amendment. It's in the Illinois Bill of Rights, and it's in the Wisconsin Constitution. It's in all state constitutions that landowners are entitled to just compensation for their land. Meaning, ultimately, if your case were to get to eminent domain, if it were to get all the way to a trial, you would have the option to allow a trier of fact, whether it's a jury, a judge, or a commission, to determine how much compensation you're entitled to. That is kind of the 10,000-foot view of what it is. Effectively, I think the takeaway is that we have to operate, and this is how A&R operates. This is how pipelines generally operate. They operate as if they already have the power of eminent domain, and they don't, but they are presumed to get it. And because this exists, it changes the tenor of the negotiations. This is because they will get this ability to acquire your land, whether you like it or not. It kind of cast a pall over the negotiations, a specter that everything is negotiated with an understanding that they eventually will have this ability to acquire the land through eminent domain. So it's not so when you're selling your property to the pipeline, it's not like selling it to your neighbor. You can't just say, no, I'm not selling it, and they go away. You have to reckon with the fact that they may eventually be able to take it. And so eminent domain, the process through which the pipeline can exercise their eminent domain, there is a procedure, and it generally follows the state law of wherever the property is located. which it will involve a pre-condemnation offer. I noticed that several of the folks here today have offers already from ANR. So this is the pre-condemnation offer, the offer they must make to you prior to initiating condemnation eminent domain proceedings. It's also where our firm gets involved. Our firm gets involved when offers are on the ground. When you have an offer, you have the ability to hire us if you'd like, and we have the ability to represent you. Until that point, it's a little premature, but if you do have an offer, that's generally where we get involved. So in the condemnation process, they have to make an offer. They have to negotiate with you. But the bar for negotiation is very low. In other words, basically, if they give you an offer, even if it's a terrible offer, they have met the bar for negotiating for purposes of condemnation, for purposes of eminent domain. So there isn't a very high bar for negotiation. They don't need to meet a very high bar of standard bar for negotiating. Generally, if they give you an appraisal, that's enough. Or sorry, if they give you an offer, that's enough. So back to the process, the procedure of eminent domain, they've issued you an offer, a deal cannot be struck. What happens next? Well, again, assuming they have their FERC certificate, assuming it's been granted, they will go to the very likely this would be a federal case. They have the option to utilize a state procedure and file this in state court. However, it's expected that they will utilize federal court, federal procedure for pipeline condemnations is a lot friendlier to pipelines than state procedure. So they will very likely sue you in the Northern District of Illinois, the Southern District of Wisconsin, wherever the property is located in that district. They will file a lawsuit against you, and then the lawsuit becomes over basically how much are you entitled to. The lawsuit serves the purpose of both getting the land for the pipeline, but also ultimately determining how much compensation you're entitled to if it gets to that point. You do not have a guarantee of a jury trial in federal court. You could get one, but you do not have a guarantee. If this were a state court matter, for example, you would have a guarantee to a state court, to a jury trial. This is also one of the reasons why pipelines generally choose federal court to file their lawsuits. So you will either you don't have a guarantee to a jury, but you could get one. You're more likely to get a commission that's appointed by the judge or the judge themselves. So this is the beginning to end for eminent domain. And I do want to stress that, not every case that we handle gets to eminent domain. And of those that do get to eminent domain, usually the cases settle at some point after that, either before or during eminent domain. I would say with utility cases, there are even more settlements pre-suit than there are cases that get to eminent domain. Most of our cases generally resolve pre-suit. But we represent folks as long as we need to get to the point where the landowner's happy and they're getting properly compensated and they're getting a good deal for this acquisition. So let's talk about negotiations. In other words, what do they want from you? So if you have an offer already, you've probably already seen, you've maybe looked at the documents that they provided, what they want. What they want from you ultimately is an easement. And an easement is essentially a deed that you're deeding the right to do something on a certain area of your property. So when you sell your property, if you're putting your house for sale, you're selling the entirety of the property. You're selling your home, you're selling the land, and you own 100%, you're giving it up, you'll own 0% afterwards. An easement, depending on who you're asking, is you're basically giving up 75% of your land in a certain area, or 80, depending on how restrictive the easement is and what it says. So it's basically like you're selling again, you're selling a certain area of your property and the right to do certain things on that area. A common example besides pipeline power line easements would be like an access or driveway easement. A lot of times folks give driveway easements to their neighbors who need to access the road. So they give their neighbor a driveway easement through their land to get to the public road. And in that scenario, all the neighbor could use that area for would be getting to and out of their property on a driveway easement. Same thing applies with the pipeline easement. However, the difference is usually with driveway easements, your neighbor isn't trying to sneak a bunch of stuff on the easement that they shouldn't be doing and trying to get more rights than what they say they want. One question I get a lot from landowners, virtually every conversation I have is the pipeline allowed to do this? Am I allowed to do this? Am I allowed to farm? Are they allowed to restrict my access? Can I build on top of it? Can they build on top of it? What rights do I have? What rights do they have? These are all all the same question effectively. What are the rights of you in the pipeline in that easement area? And my response every single time is it all depends on what the easement says. The easement is the most important document that you'll have to sign. It is the rights that you're specifically granting to the pipeline. And that will govern not only what you can do on the property, but what they can do on the property. And not only will it govern it now, it'll govern it into the future as well. So, because it is, of course, a permanent easement. So, it's important to remember that because this lasts forever, because this will always be on the title, always be on the record, it'll be on the record when your kids inherit it, when your kids' kids inherit it, if you sell it to somebody else, whoever ends up getting it, they will have to deal with this easement. So it's imperative for landowners to make sure that that document is incredibly is drafted appropriately and has the important protections for you, restricts the pipeline as much as you can, avoiding pitfalls that we've seen in pipeline easements. Now, I haven't seen yet ANR's pipeline easement on this project, but I've seen a lot of pipeline easements presented to folks across the country. And we see a lot of the same things that happen on these easements. They are poorly drafted. What is told to landowners is not necessarily what the document says. And examples of these misrepresentations that we see is there is sorry, one second. There's we see a lot of unfettered access language. So this is language that basically gives them the right to be wherever they want on the property, to access the pipeline from all four corners of the property, not just the public road, not just the existing easement. Unfettered access is a very common clause we see in these types of agreements, these proposals from pipelines. Access to the entire parcel and not just the easement area. That's in the same vein. This is called a blanket easement. And it's called that, of course, because as you might imagine, it blankets the property. It applies to all four corners of the property, and not just the area that they say. And I'll give you an example right after I turn on this light. There we go. Okay. Sorry, forgive me. So an example of a blanket easement. So I was working on a case in Central Illinois for the Southern Access Pipeline. It was an Enbridge pipeline. It came through several years ago. I think it was about 8-10 years ago. Anyway, they were wanting to build a pipeline, and very similar to this, they wanted to loop it next to existing pipeline. And what they did is they came to landowners and they said, we're going to put a pipeline in right on your property, right next to the one that's already there. And we're not going to pay you anything. And landowners would call me and they'd say, what is this? Well, this pipeline wants to build a pipeline. They say they don't have to pay us anything. They say they already have the right to do it. And I say, and I look at the documents, I look at what's been presented. And as it turns out, up and down that line, there were existing easements on most of the properties that were from 60 years ago that were granted to the Sinclair Oil Company that hasn't existed in 60 years. And they gave that original company, that energy company, the right to add not one, not two, not three, but as many pipelines as they want, wherever they want, whenever they want, without future compensation to the landowner. So that ancient easement that was drafted so long ago became a modern easement. And the utility was transferred, the easement was transferred to company to company to company, eventually ending up in Enbridge's hands. They utilized their rights that they had legally held, and they didn't have to pay anybody anything. And that's because these documents were so poorly drafted so long ago, and because they last forever, they ended up eventually becoming much more relevant than they were, and to the detriment of the current landowners of the properties. So, this is just an example of what can't happen when you don't adequately protect yourself in these easement negotiations, when you don't edit the easement, when you don't take out all of the broad language that gives pipelines the rights to do what they would like wherever they want. Again, I haven't seen this one, but I suspect there's problems with it. There normally is. So beyond that, other issues we see, the easements lack clauses for what happens in the future. They lack clauses for proper ground restoration, which for agricultural property obviously is incredibly important. They shift liability onto the landowner for the pipeline problems, the right to build more pipelines, more power lines, sell their rights to power lines, solar farms. One thing we see a ton is fiber optic cable, uh, where a um, where a pipeline easement, an easement ostensibly grants the right to build a pipeline, build a power line, but also snuck in there is the right to install communications wires, communication lines. And they tell people, well, that's just for our purpose. But if you read the easement, it's not that. It says they have the right to build this, the communication lines. What happens is then the pipeline takes those rights that it got from you legally, it subleases it subleases its rights to a cable company, a fiber optic cable company, and then they run fiber optic cable through the easement, and the pipeline gets paid for it because they subleased it and they already bought the right to do that from you, and you don't get paid anything because you already sold that right to the pipeline. So this is an example of just one of many that happens with these easement negotiations, where they sneak these things in that need to be taken out. This is kind of along the same vein. Heartland is going to run parallel to existing lines. I know I've spoken to people already that already have one, two, maybe even three lines already on their property, and this will be the fourth. So it's important to, again, make sure that these issues don't exist. They can be exacerbated. Even though you might have several pipelines on your property already, a fourth one that's incredibly poorly drafted might exacerbate the problems that already exist. It might render the property unusable with that many pipelines with poorly drafted easements. So what I tell people, these are things to look for. What do the existing easements say? I think that's also one thing that's important, because you might see a scenario where A&R might talk about how they already have the right to build this pipeline. So what I tell people is verify. And if you haven't already, I would get a copy of any existing easements on your property, because they might lean on those existing easements during these negotiations. So I tell people to go to the county recorder's office, go to the county deeds office, and say, I'd like to see all the pipeline easements on my property. And they should be able to give it to you. You just give them, either show up or give them a call, let them know what you're looking for, and they should be able to provide it. And that way you'll have a clear idea of what rights already have been sold off on your property in relation to what A&R now wants. It's because, again, you might see some of the problems that I talked about on these old easements that are going to reveal themselves here again. Ancient easements become modern ones. So it's important to know what the ancient easements are on your property, if any, to protect against those errors again, of course. So again, what I tell people is right now, when they ask me what they can do with the pipeline, is there anything I can do? If you have an offer, I would talk to an attorney. If you don't have an offer yet and you're still waiting, I would go to the county's recorder's office. I would get a copy of the easements that exist on my property and see what I'm dealing with already, so that you have a full understanding of your own property before they come in and they start talking about making you an offer and what rights they're going to utilize. So we talked about easements. I want to talk about money. There's really two components to every pipeline acquisition. It's the money and the wording. Is the wording right? Is the money right? A complete compensation package. So this is somebody who got what you would deem a complete compensation package. They got a good deal. so to speak. It should have a proper price per acre for the land that's being acquired. It should have a proper payment for any crop or timber damages that are expected to happen or that will happen, and then proper language that demands that payment in the future. There should be payment for anticipated soil and ground damages, or again, or a clause in the easement agreeing to remediate and restore the land. I'll tell you, I did a pipeline down near St. Louis in St. Charles County, and going up to Jerseyville, Illinois, and that is it's near the Mississippi, it's near the Missouri, and it's a rough area for agriculture, a lot of water, and the pipeline that was building it did an awful job of restoring the land. They did not segregate the soils. They did not segregate the sub and the topsoil. They did not exercise proper construction techniques. They left debris everywhere, and not only that, it rained a ton. It was a rain event, 100-year rain event that made everything even that much worse. And now, thankfully, we were able to get those folks paid for these damages, and we were able to get an easement that required that they fix everything. But there were a lot of folks that didn't have the deal that we got, and there was no requirement that the pipeline come back in and fix what they did because it wasn't part of the easement. That's an example of what can happen during the construction of these projects, these pipelines, and why you need strong language, why you need to get paid up front for these issues. And if anything comes up in the future, you need to get paid for that as well. It needs to have a proper consideration of all damages: field tile, irrigation, compaction, soil mixing, debris, flooding, things I just talked about. There needs to be a consideration of these possibilities, either payment or language in the easement that requires they come in and fix, and not only fix, but do a good job fixing it. Residual damage. This is a big one. And that is damage for any impact that this pipeline might have on the rest of the parcel. And now, because this pipeline is being added to existing pipelines, our residual damage is a harder thing to calculate. Usually, residual damage exists on land that doesn't have utility easements, and when one gets added to it, what's the impact on that pipeline on the rest of the parcel, and how does it affect the entirety of the parcel's value? That's an example of residual damage. So it can come in many different ways, any different types of causes for residual damage, but effectively it means the same thing. How does this pipeline affect the rest of the parcel? How does it affect the other acreage that's in play? And that's something you're absolutely entitled to. And this, of course, these are all in addition to any bonus payments that are offered by the utility. I'm not sure if they are offering bonus payments on this. A lot of pipelines do. But you should be able to get this in addition to anything that they are offering. And again, ultimately, your argument for compensation will be affected by whether or not you have an existing easement on the property and what that easement permits. I'm not going to sit here and say that you're not entitled to anything else, but it's a harder argument to make. One you certainly could make, but the damage is lessened to an extent when there already are easements on the property. But you should still get all of these items and potentially more depending on the parcel. Every parcel is different. Every parcel has different issues. One issue that I didn't touch on, I would like to touch on, is if this pipeline is coming particularly close to a home. If it's close to a home, that can have a huge impact on that home's value. And that is an example of residual damage, and one you're entitled to. Nobody wants to live near a pipeline. And when you get particularly close to homes with the pipeline, the homes can lose value, and you are entitled to compensation for any lost value from that pipeline's impact. Now I want to talk about right-of-way agents. So we have dealt with quite a few right-of-way agents over our history. I've dealt with hundreds of them. We've kind of see what they do. We know their tactics. We know their strategies. I think it's important to remember when dealing with right-of-way agents, understand what their goal is and what their incentive is. They'll say that they're looking out for you, but they're not getting paid by you. They're getting paid by their right-of-way company, who's getting paid by the pipeline themselves. And the pipeline's paying the right-of-way company a good amount of money for those right-of-way agents to get your land as cheaply and quickly as possible. That's their job. They get paid based on how many parcels they lock up for the low amounts of money that they want to get it for. They are selling you on the concept of you selling them your land for cheap. So just keep that in mind if you happen to talk to them, if you happen to deal with them, understand who's getting paid and why they're getting paid and what for, what their motivations might be. But these are some things we've seen in their effort to sell folks on the offers that are presented. They have these tactics, these strategies that are, these are industry standard. They do this across the country. This has worked before, and they'll do it. They'll do it here just like they do it anywhere else. And they'll say, "Oh, we're offering you 125% of fair market value." They're giving you a deal, as they like to put it. That's one thing they like to get on your side and say, "We're giving you a deal. I'm doing you a favor. We're giving you more than the land's worth." All of these things. But that according to who? And if you're focused on that, you maybe not be focused on something more important like residual damage or the easement's language. Bonus payments, again, they want to get on your side. They want to, they'll either be your best friend or your worst enemy, as I've seen. It's kind of a good cop, bad cop scenario where they'll try the friendly route. They'll see if they can get on your side. Hey, we're giving you a good deal. And if that doesn't work, they might flip on a dime, and now they might be mean. And now they might be say, well, if you don't accept this, we're going to lower it. Or if you don't accept this, we're going to take you to eminent domain. We hear that a lot. Threats of eminent domain are common in this line of work, especially when they don't even have it. It's used as a threat. Timber, crop damages, these are things that they offer up that they have to pay you for anyway. They have to pay you for your crops, but they're offering it again to make it seem like it's a good deal. Shell game, you've seen the shell game at the fair where find the ball under the shell and they move the shells around on the table. They want you focusing on the things that they want you to focus on. They want you to quibble over crop damages and the price per acre of the easement. They want you to ignore what the easement actually says and what type of rights that you're actually signing away to them. This is a shell game. This is to distract you from the important issues of your case. And that they play this a lot. Distraction, focus on what they want to focus on, not what you should be focusing on. Understand that your ability to say no gives you leverage. You do not have to say yes when they come in and make their presentation and offer you a paltry sum for your land. You don't have to say yes. And the ability to say no comes with leverage. And leverage always equals more money. I see a lot of verbal offers. They like doing that. They love saying, "Oh, let's talk about it. Let's keep this verbal. Let's not write anything down. Let's go off the record." That happens quite a bit, and it's easy to make these verbal promises because they don't mean anything. If they want to make an offer and they want to verbalize it, they can write it down. They can put it in an email. They can send it, and they can tell you because otherwise it's not worth anything. It needs to be in writing. Lowering and raising offers, going up and down, accept by this and you get this, don't accept, it goes down, all of these things, putting you under the gun, making you make a quick and hasty decision. And quick and hasty decisions, especially in this context, are usually bad ones, usually poor ones. If you're making a quick decision, you're probably not making a good one here. Ultimately, if you aren't sure if the offer presented to you is not a good offer, all you have to do is email me, call me, shoot me a text, say, "Hey, here's my offer. Is it good?" And I'll look at it for free and I'll give you my thoughts and I'll tell you what I think about it. Again, for free. We don't bill for case reviews, for consultations like that. I'm happy to look at any offers you might have and give you my honest evaluation. Then you can decide what you'd like to do and how you'd like to proceed. But we will definitely look at your offer for free. So now that we talked about what they do, let's talk about what you should do. And, some folks here don't have an offer yet. I want to tell you that if your property is affected, and we believe it is because based on the information that was presented to FERC, which gave us the information that allowed us to mail to you, we believe your property is affected based on the information that ANR has submitted to FERC. So what that means is that if they need your land, if we're correct and your land is affected, that they will need to come to you and they will need to make you an offer. I will also say that it is not a light touch. Some people are concerned if they don't have an offer. They say, "Am I doing something wrong? Did I miss something? Have I not? What did I do?" And the reality is, again, it is not a light touch. When they want your land, when you are on the schedule to receive the offer, you are going to hear from them. They are going to make their presence felt. They're going to stop by. They're going to call you. They're going to email you. They're going to send you mail. They're going to do all of this. It is going to be it's going to be very obvious when an offer is issued. And until that point, there's not really a lot that you can do to speed that process up. We kind of go at their schedule with regards to receiving offers. But I just want to talk a little bit about whether or not you have an offer and what that might ultimately mean. Again, I wouldn't take it to mean much because ultimately, again, if they need it, they'll come to you. So let's talk about what to do when they do come to you. Well, we talked about the pitfalls of verbal discussions, having these verbal negotiations with the right-of-way agent. They don't help you. They're off the record. They can say whatever they want and it means nothing, which is why we tell folks, and when they come to you and they say, we want to make you an offer, say, you can email it to me. Say, you can email it to me. Here's my email address. Send it to me, and then I'll look at it. And then once you get the offer, you say via email, "Thank you. I will review this and get back to you in a week." And then in the interim, you contact an attorney, take a look at that offer, and you decide what you want to do. And the reason why I'm very specific about this language is that this allows you some space. It allows you to gather yourself, prepare a plan, get a strategy in place. Gives you a week to decide what you want to do. A week is good because you're not blowing them off. A right-of-way agent will generally respect this and say, "Okay, a week's fine. I'll give them a week." If you ask for more time than that, they're probably going to insist on meeting sooner or stop by in the interim and try to have a conversation, try to meet at your dinner table and have a discussion about that. If you say, "Give me a week," they should respect that and it allows you your time to do what you should do. It also it serves the function of getting the offer package via email. Because a lot of times they'll mail it or they'll present it in person, which makes it more difficult to give to attorneys or whoever you want to review it. This way, you'll have an e-copy of it. You can just forward it to whoever you'd like to take a look at it, and it makes it easier on everybody. The final point, avoid in-person discussions and negotiations. It doesn't serve you to have an off-the-record discussion with a right-of-way agent because their promises mean nothing. If they have promises they want to make, they can email them, they can text them. Anything that has a writing, anything that you can look at and say, "Okay, this was promised to me." If they're not willing to do that, then you're not having the right discussion. There's nothing to benefit from illusory promises that may never come to bear, that don't find themselves into the easement that are made by right-of-way agents. So that's what you should do, what not to do. Again, don't just jump into negotiations. Don't just start rattling terms off, what you think you should get, what you think your land's worth. Don't just jump in. It might seem instinctual when they come to you, you make an offer to just start talking about property value. But the reality is that you might not know what you're entitled to yet. And if you go to them and say, "Well, I think I should get $60,000 after they issue you an offer of $30,000. And then you contact me and I say, "Well, actually, you should be getting 90 or 120. And the problem is you already told them that you would take 60. And when you told them that, they wrote it down. They always keep contemporaneous notes of their conversations that you are not privy to. They keep notes. They'll write down that you accept $60,000. And that will travel with you the rest of the case whenever it resolves. It'll go to the attorneys at A&R. It will go to the management. It will go to the project manager. They will know forever what you were willing to accept. And that's even though you might be entitled to more. You've already screwed yourself, even though you didn't even know what you were potentially entitled to. So that's why, again, I don't recommend jumping into these discussions and having them, at the very least, without getting a second opinion. Don't enlist an appraiser. I say this a lot because they're not necessary. They are generally not necessary until you get to litigation. At litigation, they can be an important resource, an important tool for landowners. But until that point, you're just spending money on something that ultimately the pipeline can ignore entirely. It's not worth the many. Eminent domain appraisals are not cheap. Pipeline appraisals are not cheap. And if you can get a deal without having one and spending that money, I'd say that's a better scenario. And almost all of our pipeline cases, the only cases that I have, pipeline cases that require appraisals are cases that have reached litigation. And at that point, you might want to do it, but before that point, there's no point in investing that type of money in that type of cost when you might not need to do it. Again, don't meet in person with the right agent. Keep arm's length, email, text, avoid phone calls. Just make sure there's a record, make sure there's a writing so you can point to everything you need to. Again, don't take right-of-way agents' promises at face value. Do not assume utility has your interest at heart. And do not make a rush decision, but also don't ignore it altogether. I have folks that do either or. They kind of rush into a decision or they put it on a stack of papers and don't address it for months. That can also get you in trouble, where you ignore it, you don't want to deal with it, and then all of a sudden you're in court and you don't even know what you're doing there. So I just don't, you're already here, so you're not doing that. That's important. But again, the more important, I think, takeaway is not make a rush decision. Jumping into signing a document that you don't even know what it says is a recipe for disaster. So some common questions I get that I feel like I want to address. Do they have the right to survey your land? Yes, they do. They either have it through the existing easement or they have it as a matter of law with their FERC application. How do you find out if you have an easement on your land already? Contact your local recorder, contact your local deeds office, tell them what you want, any easements on the property. They should be able to walk you through exactly how to do it. They might just give it to you and send it to you via email. It might cost you a couple bucks, but it's definitely worth it to have that knowledge. How do I find out how much land they want, where it will go? And this is a question for folks that don't have offers yet. You are not going to know the nature of this acquisition until they present it to you. You're not going to know how much acreage in permanent easement they need. You're not going to know how much acreage they need in temporary easement until they offer you. You're not going to know any of that until they come to you and they present that offer. Some folks ask me, well, do you have maps? Can you tell what it is? We have maps, but the maps only show where the line's going. They don't show the granular details of the easement itself. Those details will be in the offer package that they present. It'll say how much acreage they need, how much square footage they need of each type of acquisition, temporary, permanent, access roads, what have you. If you have an existing gas pipeline easement, I think it's fair to say that it'll likely be right next to it or parallel to it. That's an assumption. Of course, I don't know, but since this is a looped pipeline, it's probably going to be right next to the one that's already there or the several that are already there. What if I'm never home? That's a question. You're never home. How do you know if you're going to get an offer? What if they can't get it to you and all of a sudden you're in eminent domain? Again, if they need to get you something, they will make their presence known. They have resources. They have the ability to, get you mail, get it to where it needs to go so that you receive the offer. They need to give it to you to meet pre-condemnation requirements. What if it goes through a building? This is a question I get a lot, and it's kind of similar to, can they build a pipeline that close to my home? And the answer is yes. They can put a pipeline basically wherever they'd like, and that includes going right through the middle of homes. Now, of course, they're going to have to buy your home if they run through the middle of the home, but there's nothing stopping them from going through homes. There's nothing stopping them from putting the pipeline 5 feet from your front door if they want to. What you need to do is get paid for it and get paid as much as possible if that's the case. But it's one question we get a lot. How is it? Can they just put it there? Can they put it there? Yes, is the answer. They can put it wherever they'd like to within the certificate they have sought from FERC. So this is a response situation. You need to respond to what they do. Unfortunately, there's not a lot that you can do about that type of acquisition. So now I want to talk about, and I'm nearing the end, and I apologize, I'm running a little bit long, and then we'll open it up for questions. I just want to, real quick, folks that are seeking attorney, are interested in hiring an attorney, our firm operates on a contingency fee basis. If you're interested in legal representation, you want to hire me to handle your compensation, handle your easement language negotiation. We work on contingency. If they come through, an example of that, if they came through and they offer you $10,000, you hire our firm and get you $50,000. In that scenario, there's a $40,000 difference. Our firm collects a third of the 40 that we add to the case. You get the rest. So we collect a third of any amounts recovered over and above the offer issued by the pipeline. One question I get a lot: what happens if you don't get another dime than what is offered? Then I don't get paid. Very important. And that means if we're taking on your case, it's because we're investing in it. We're investing our time because we see a recovery for you, we see a recovery for us. And so it's important that, if we're taking on as a case, it isn't for fun, just for fun to take on clients. We're taking it on because the easement needs to be changed and the compensation needs to be increased. And we'd like to help you get to that increased compensation. The reason why we do this, it allows landowners to hire attorneys, allows landowners to hire us without coming out of pocket. If you were to hire our firm, it's as simple as signing a contract. We contact the pipeline, we take it from there with input from you, of course. But there's no out of pocket. Money is exchanged at the end. You don't need to pay me $5,000 to handle your case, and I'm billing at $500 an hour. That's generally not how we work. We do it this way, again, because it allows landowners to not need to come out of pocket, but there's also a trust issue. We're invested in the case too now. We're partners, and we are strong. We are incentivized to get another dollar for every last dollar because we're part of that part of that investment as well. Every extra dollar we get for you is 33 cents for us. So it allows a level of trust between landowners and our firm. We're all in the same boat, doing the same thing. So that's, and most landowners prefer this method of contract with our firm. So that is how we operate. Okay, and now with that being said, if you have questions, go ahead and start asking them. You can put them in the chat. Yeah, go ahead and put them in the chat. There might be a Q&A. There's a Q&A section as well. Either one, put your questions in there, and I will address them once we're done with this slide. So moving forward, next steps, as soon as you hire an attorney, or excuse me, as soon as you receive an offer, you should hire an attorney. Until then, I would say begin vetting your options, getting a plan, getting a strategy of attack. How are you going to attack this acquisition? How are you going to approach it? Identify your priorities, your goals. What do you want out of this? What are concerns about your land that you want protected? Is it livestock? Is it fencing? Is it the soil? Is it timber? Is it hunting land? All of these things. Start thinking about what you're concerned about, so that when you do hire an attorney, you have something to present to them to say, this is what is important to me. Strengthen numbers. If you have a group of landowners, it can be very helpful for the landowner. It provides a lot of leverage for landowners that are in groups, because a large group of landowners, especially one that's represented by the same council, has more leverage than an attorney representing a couple landowners. So for example, if I go to A&R and I say, listen, I got 40 folks here that are not happy with this easement, they're not happy with compensation, they're going to listen to that. If I come to them and say, well, I have 4 clients and they're not happy, all the same things, they're still going to listen, but you have more of their attention in the first group. The point is to get their attention, to show the risk that exists for them if they don't compensate you properly, if they don't draft the easement appropriately. So the way to increase your leverage is to have a group. It's not required, it's not necessary, but it is something that if you can get your neighbors together and all kind of join in while still having your own individual case, it can increase your leverage, which, as I stated earlier, that's how you increase your money. With that being said, that is the end of my presentation. That is my email address. That you can that's my cell phone. You can text to that number. You can text pictures of offers. I have no problem doing that. Just text them to that address. You can fax it to our fax address. You can mail it to our mailing address. However is easiest for you to get me your offer. I'm happy to look at it for free. Again, I don't bill. You're not going to get an invoice for this. It's as simple as me looking at it, and then we can talk about it, and you can decide what you'd like to do. And if you don't want to hire us, that's fine. We go our separate ways, and you hopefully get the help that you need in some other form. So happy to do it. It's my pleasure. So again, that is the end of my presentation without questions. But if there are questions, please go ahead and ask them so I can get them answered if they exist. Okay, there's a question. I'm particularly concerned about future buildability on my property. I've already corresponded with A&R. Can I forward the emails and all their offer? Yes, you can. Feel free to send me what you have. I'm also concerned that A&R has asked for a secrecy clause and to not file documents regarding the easement. That's interesting. I'd like to see that so that I could talk about it further. A secrecy clause. I would like to review that and see what they're interesting. If it's a non-disclosure for maybe your compensation, I can see that. I've heard of that. They're not that common, but pipelines do a lot of things. I'd be very interested in seeing what that says. I'd be concerned about it as well. And as far as the buildability on your property, yes, the ability to not be able to build on your property, you're not going to be able to build over the pipeline easement. That is one thing that is non-negotiable. You're not going to be able to build structures. You're not going to be able to, build anything really. I mean, you could put you could put maybe fencing or some light gravel or something like that, but you're not going to be able to build, and that carries with it an impact, especially if it's a commercial property or you're around commercial development, and that property could have been developed, would have been developed. You can definitely make that argument. Another question. In addition to existing pipelines put through prior to my ownership, fiber optic line crosses the proposed and existing easements. What additional concerns and liability may be added? Um, if it, I guess I'm a little confused by the questions, the question itself, but it is an example of what I talked about earlier, fiber optic cable being run through existing easements, an issue that comes up. Is there additional concerns or liability from fiber optic cable specifically? Or are you just I guess I'm a little confused by the question. Is it generally concerns or specific to fiber optic cable? So if you can clarify that, I'd love to answer that. Um, but ultimately, the other concerns that you need to have, liability is a big one. And, does the easement shift liability to the landowner? If there's an issue with the pipeline, if the pipeline explodes, are you liable just like the pipeline is? Those types of things. Or if they do something on if they do something on their easement that causes damage to somebody else, somebody physical, personal damage, etc. Then are you going to be liable for that? Are you going to be brought into a lawsuit because of something they did? These are things you can definitely take out. So the clarification was, are there additional considerations specific to fiber optic? Well, the consideration is it shouldn't be part of your existing easement. Fiber optic cable has nothing to do with a natural gas pipeline. What it does have to do with is them making some money off their easement. So if I'm taking a look at a proposed easement on your property, and part of that easement involves the addition of fiber optic cable, that's the first thing I'm taking out and saying, no, you want to build a pipeline, not fiber optic cable. If you want to get a fiber optic cable easement, then you can pay whatever the market price is for that. Otherwise, this is pipelines and pipelines only, or one pipeline only. So I guess with regards to fiber optic, specifically, it just shouldn't be in the easement to begin with. It's not something that they should have the right to acquire from you. A&R has not been able to make any timetable commits, said might be up to 6 months. Are there any loss of use considerations? I have a stable. So there should be, if you're not able to use your property for some period of time, um, the clarification, building the pipeline and drilling under rail tracks. Um, sorry, I'll answer the first one. There might be up to 6 months. Is that 6 months of construction or 6 months until they begin construction? They're not going to commit to, yeah, 6 month construction. They're not going to commit to a timeline of construction. I'll say that. They generally don't commit to when they're going to start and where they're going to end because weather and all sorts of factors come into play that will prevent them from committing to a specific time. But which is why your agreement needs to encompass any of the possible issues that could arise, aka construction lasting for longer than 6 months, construction lasting a year, you not being able to use your property. What are the damages associated with that? That needs to be part of the agreement, or it needs to be paid up front. Having these contingency possibilities written into the easement such that construction lasts so long that it impedes your farming, impedes this, or what have you. There should be a clause that requires them to pay any damages associated with that. Concerned with the pipeline damaging fiber optic cable, that's the clarification. Let's see, a fiber, what may be added? I guess I still, I guess I'm still a little confused. Concerned with the pipeline damaging the fiber optic cable. Oh, okay. I think I understand. You have existing fiber optic cable and the pipeline's going through it. So it's just a standard cable easement and the pipeline's going through it. And you're concerned with the pipeline conflicting with that existing easement and affecting your service. There should be coordination between the easement holders. And that will, again, need to be put into an agreement such that any construction that they undergo can't affect negatively, or if it does affect negatively fiber optic cable, other issues that might exist, it needs to be very clear in the easement that they're responsible for any damages associated with that, or they should take certain precautions, concerns when doing doing construction to avoid that type of damage. It seems to me that pipelines are commercial projects. Are there any cases that define the purpose and compensation in regards to pipeline through vacant farmland to this effect? Not they absolutely are commercial projects. I'll say that. Are there any cases that define the purpose and compensation? So with regards to specific eminent domain cases about what you're entitled to, you are entitled to at eminent domain, you are entitled to the fair market value of your property. And that's the fair market value of the property they're taking and the difference in the value of your property before and after the acquisition, after the easement. What's the difference of those two plus the acquisition itself? Your compensation itself has nothing under the law, and this is using eminent domain law. Your compensation is not tied at all to how much money they make. And I think that might be what you're getting at. And it's a question I get a lot is they're making so much money off this project, millions of dollars. Shouldn't you get something commensurate with how much money they're making specifically? And if you ask me, I agree. You should get something. Unfortunately, the law does not consider the financial benefit that is bestowed on the pipeline in determining the compensation owed to you. So they could make 10 billion or 10 cents off this pipeline. That does not affect what you're entitled to for the acquisition of your property at eminent domain. Okay. If you want to talk about how much money they're making, the court's probably not going to let you. Fair market value of your land. It does not take into consideration how much money the pipeline's making itself off this. Again, I wish it were the case that you could get paid based on how much money and financial benefit they're earning. Unfortunately, it's not the case. Is it possible to make the pipeline company dogleg around my property and through vacant farmland? So this would be basically, can I move the line? And I will say that sometimes you can, sometimes you can't. More often than not, the changes you and the likelihood of them being willing to do it depends on what type of change you're asking, what type of, your property, its location relative to everybody else. One small change in this pipeline can have a ripple effect down the line. So a large change can have an even larger issue down the line. So whether or not they're willing to change it, ultimately you're kind of at their whim. I would most of the time they're not going to change it. They might move it over a couple feet. They might, do a little bit of a change. Any significant changes, moving it entirely off your property, making it, take a detour around your land, that's going to be less likely. There's no harm in asking, of course, but I would not expect a ton of, I would not see results. I wouldn't expect results on that. Just because, again, they know what they can do, and they know they can get your land, and they know they have this significant power or will get the significant power. So they wield it. And that's one of the ways they wield it is by saying, this is where we want to put this line. Now, we might pay you, but we're not going to pay you what we want. So it's important, that's kind of how it works. They just kind of put it where they want and let the chips fall. They're very successful and they understand that, they have a lot of power in this scenario. So, but not they don't have all the power. You have the ability to negotiate your deal. You have the ability to negotiate your language and potentially get some line changes. But I just wouldn't hold my breath if I was trying to make a significant change such that I think that might be where you're moving it entirely off your land onto your neighbor's property and other people's property. It's possible, but it just is not. It doesn't happen that often. Would reverse engineering a solar contract be a good tactic to use when asking for compensation for vacant farmland? So basically, as I understand it, you're getting a solar contract to make your property more valuable such that you can get paid more for the lease that it is taking out or it is affecting. Well, you're gonna have to find a solar company that wants to do that. It's something that I think would be better served talking about individually. That's I'm happy to answer that question maybe on a phone call. How about that? Yeah. Yeah, let's talk about it another time. Other questions. Okay, I'm not seeing any other questions. So unless there is anything, I'm gonna go ahead and wrap this up. If you think of something later, shoot me an email. You have my email, you have my phone, you have everything right there that you need to contact me. Shoot me your offer, send me your offer if you have it. Happy to look at it. We can set something up, set up a call. Here's a question. How are disputes over the terms of the easement resolved? So that's a good question. In negotiations, the disputes are resolved through more negotiations. It's me saying I want this changed, them saying, no, me saying yes, back and forth until a deal can be struck. Ultimately, at eminent domain, they'll file the lawsuit with the easement that they want. You might be able to raise an objection at eminent domain to the easement that they propose at that point. Excuse me. But ultimately, when you get to eminent domain, they'll file their lawsuit with the easement that they want or some variation of it. So the disputes over them in negotiations are handled through negotiations. Disputes through existing easements and, down the road, for example, constructing how to construct if there's a violation of the easement, determining there's a violation, what's the remedy, what are the damages, so on and so forth. those are handled by courts. That's a matter of contract law. The determination of what your contract, because an easement's a contract. What does it say? What are the duties of both parties, and have they been breached? So they are handled, the disputes over existing easements that have been signed by both parties. They're handled, by the court system generally. You can file a lawsuit for enforcement of agreement. Second question, do the pipeline carriers have demand rights to certain terms? Um, I think I understand this. They do have certain things that they want in their easements, that they'll ask for and say, we need this because of this reason. We need the ability to access the pipeline because it's important to the construction of the project. And is there a necessity to, okay. Is there a necessity test? That's a good question. Necessity is a question of how necessary is the acquisition. That's an eminent domain where it needs to be for the public convenience and necessity. And that beyond that, what they're taking via the easement is necessary for their construction of the pipeline. What I'll tell you is that for everything they have in the easement, they will have a reason for why they need it. They will say that we need this because of X. We need this access provision because of we need to access it from these dates to these dates at these times during this weather, so on and so forth. So that's how it's they basically have a reason for most of their language that they have and that's where they deem their necessity. Also, we are not. I saw someone raise their hand. We're not actually taking questions. So if you have questions, put it in the chat. Once an agreement is reached and signed in the future when this pipeline goes in, can any changes be made? No. Well, they could, but you need their consent. So you basically need to do it and then get they have to sign off it as well. And as you might imagine, they are very unlikely to do that. So once the agreement's signed and recorded, that's your document. That is going to be it for now until it expires or it extinguishes. And it only will expire if there's language in the easement that says that it expires in certain situations. So by and large, if you sign it, that's going to be the document you're going to have to deal with forever until, I mean, that's going to be it, but for all intents and purposes. They have arbitration in their contract proposal. That would seem to be expensive for me as a landowner. Is requiring a jury a better option? I don't know the context of the arbitration. I don't know if it's arbitration to handle damages or something in the easement, a conflict, a disagreement, and what the construction of the easement says, that you agree to a binding mediate or arbitration. Arbitration is never in a landowner's favor. And that's the case with not only this, with pretty much any area of law. If there's an arbitration clause that basically whoever's signs away the right to a jury trial and instead consents to an arbitration process instead, that is never in that person's favor. It is always in the corporate individual's favor to do arbitration as opposed to jury trials. So yes, requiring a jury trial is almost always a better option than arbitration. Can they use the process to expand their rights beyond what is necessary? I don't. Can they utilize eminent domain to expand their rights beyond what is necessary? They can. They need to, I guess it's a little confusing. What presumption of necessity are they entitled to? A very high presumption. They're entitled to, if you're talking about the necessity of the project, that is going to be accomplished through the certificate of public convenience and necessity. If you're talking about necessity to include certain things in the easement specifically, generally there is a presumption that, and this isn't case law, but there is a general deference to condemners, pipelines, power lines, road builders, that what they want is what they need. And that's not always the case. And if you can make a coherent argument that they don't need something that are asking for, then you can win on those grounds, or at the very least get it amended to take those grounds out. What I'll say again is that courts, a lot of judges will defer to the condemner, the pipeline, and say, well, if they really need this, then and they give any reason for why they need it, to build the pipeline, to maintain the pipeline, to construct the pipeline, they're probably going to win on those grounds. I have an offer. I have an offer, but they want me to sign an easement over, but ask I wait for payment up to 45 days. Um, they want me to sign an easement, but ask I wait for payment for, yeah, 45 days is very long to receive payment. That's way too long. If I'm signing something, I'm getting payment, within weeks. If that, that's 45 days is way too long to receive payment. I would definitely negotiate that. Future dispute on the contract. Yeah, and that's referring to the arbitration clause. Yeah, if there's a dispute on the easement, then you go to arbitration and arbitrator solves the problems. For those who don't know what an arbitration is, it is a quasi-judicial procedure. It's basically a private legal proceeding, no jury trial, involving designated arbitrators who basically handle your case as if they're your judge, but it's not a legal proceeding. You're involved. It's a private legal proceeding. So it's kind of like a private court system that you don't get a jury. You just get some usually retired judge or a retired magistrate to basically determine all the issues of the case. And those generally favor pipelines. They generally favor whoever's asking for them, big companies, insurance companies, so on and so forth. They love to include arbitration clauses because generally and on the whole, they benefit them versus you. I don't, that's assuming it's forced onto you. I generally the arbitration clause finds its way out at eminent domain. So they're not if they're I rarely the arbitration clause is taken out at eminent domain. It's usually something that they do now during private negotiations. So it's something that generally comes out when the court gets involved. If any agreement is paid and the pipeline does not happen, can they ask for the money back and cancel the easement? Uh, Only if there's some language in the easement that allows that. That's actually one thing that has happened before, where folks agree to a pipeline easement, the pipeline isn't approved, or the pipeline decides they don't want to build it, or it just doesn't get built, but they already paid you. Unless there's something in the easement that says you need to pay that money back in this situation, which I wouldn't put it past a pipeline to put that type of language in it, but it's pretty rare. Uh, Generally, those clauses aren't in the agreement. So to answer your question simply, no. If you sign an easement and they don't build it, and there's no clause in there requiring a payback, which there generally isn't, and probably isn't, then you are sitting pretty because you got paid for nothing. Now, what can happen is and this happens a lot as well, you might be saved in the interim, but it might end up coming back to bite you, is you agree to the easement, this pipeline isn't built. Let's say A&R goes bankrupt and they can't build this pipeline. But there's this easement that you signed and you got the money. What happens then? Well, the easement still exists. It belongs to a bankrupt company, but it's still on your title and it still exists. And what happens to that bankrupt company? Its assets get liquidated, its assets get sold off. And eventually that pipeline gets traded around before Enbridge gets its hand on it. And not only does Enbridge buy that easement, but it buys maybe the other 100 or so easements that it acquired on this project before it went defunct. And what does Enbridge then try to do? Enbridge is another energy company, by the way. What do they try to do? They're going to do what A&R failed, and they're going to come back and build that pipeline. The good news for them is that they already bought a bunch of these easements that A&R bought. So they already have most of the easements and they can use them and to build the pipeline. that they purchased from you originally. So that's just a scenario, but in this immediate situation, you would get paid for nothing. If you discover an easement that was not revealed to you when you did your due diligence prior to purchasing your property, will your title insurance pay for that? So that is a question that we get a lot. That would be an issue between you and your title company. That they warrant the title that they give to you, and it should have been included in their title report. And if they didn't disclose it to you, you might have an action against them. It's a little outside of our purview, but that is something that I would look at, whatever your title insurance agreement was and what they warrant and what with regards to the title that they presented. And if they didn't disclose that, I think that you might have, again, without getting, I don't want to say if you have a case or not because it's not my area of law, but you could potentially. But yeah, so I would look at my agreement with my title insurance company and see what the liability exists, if any. Other questions? Okay. All right. Well, I'm going to thank you guys all again for um, joining me this evening. I really appreciate it. You guys have been great. Some great questions. Again, questions, don't hesitate to contact me. Shoot me an email, shoot me a text, uh, mail me your offer, do whatever you need to. Happy to look at it and be in touch later. And I'm going to end it with that. Thank you so much for stopping by again, and good luck and contact me with questions.